can a federal trial court hear matters of state law and vice versa? Well, this brings up the question of subject matter jurisdiction. A federal court has subject matter jurisdiction over federal law issues and cases where the parties are from different states, or where one state is suing another, or where an individual is suing a state. So in all of these cases, and in the last three there, if the individuals are suing under state law, then in that event, the federal court can hear state law matters. Likewise, if a dispute between individuals or a crime involves state law and federal law causes of action or charges, then the federal court can hear the federal and state causes of action. The federal court will simply apply state law to the state causes of action in that situation so they can adjudicate both. But to have a federal subject matter or a federal law at issue gives the federal court the ability to also hear a state law matter associated with the same conduct. Now, often if the conduct is too far separated from the federal cause of action or federal law at issue, then the federal court will dismiss that portion of the case. Now, on the state court side, state courts as well can hear matters of federal law if they come in conjunction with state law matters. Now, generally the federal cause of action has to be ancillary to, and the primary matter at dispute needs to be a state law matter, but they are vested with authority there, and the state court would have to apply federal law. Now, the parties, because it does involve a federal matter, have the ability to request to remove the case from state court to federal court at any point in time. But again, the state court does have that limited authority to hear matters involving federal subject matter. So again, even though federal courts have subject matter jurisdiction over federal issues and state courts have general jurisdiction over state law matters, there is that slight overlap in their procedure as to what these courts can adjudicate.